Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything. Because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay. So understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test you, and you're going to have. Do you show a Texas driver license? Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Felicia, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants, and let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'll be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just, it's so much baggage. He scares me, you know? And
he does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this, you know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, no. Right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot. And, you know,
this judge isn't pulling any punches. You can hear the exhaustion in her tone. 3 states, multiple thefts, and the same pattern again. That's the kind of record that makes judges lose patience. But here's the question. Should fear of repetition justify denying bond entirely? It's a tricky balance between public safety and second chances.
You know, so I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey, happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, R-I-L-E-Y.
Morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the.
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
What's it to be? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know.
So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. If I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. So as soon as I go up there, he gonna walk me out. I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is a state requests a bond of $7,500.
Judge, we'd request a bond set of 1,000.
Big difference.
It's a pretty big divide, Judge.
So the problem is that because you're a fugitive, right? You are an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
It's too low. I mean, that's what we do on normal cases, not just, Unless
I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, unless I get new information.
I don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500. Okay. And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Reach out to your folks, your family to see whether you guys can make it. And
Under 2,500.
this is not I'm not going to negotiate with you, dude. This is just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding the council and the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond until, if that's okay with court.
25, like,
Don't argue with it.
no,
Okay.
no, I'm not arguing. I just want.
Here, look, let's do this.
My job and everything.
Let's do this. Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dane. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the
So
complaining
my
witness in the
understanding is
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 0.8 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. When you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there are serious consequences. I'm now revoking your bond in the harassment case. You're staying with me. Now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still gotta go to rehab?
Then we'll talk about that.
We'll work through all the, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence, and the way that I do that are with these devices, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Schreiber's been living in a hotel. They've abided strictly, even with their communication and transportation today, with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of counsel's represented, and we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues?
That's why I'm going to rehab, sir. Yes, sir. I understand.
You know, there are people in life when they drink, they're very happy. They're the life of the party.
That way.
Yeah, and then there are people who develop horns when they start drinking. If this is you, there's one easy solution. So what we'll do is I'll put the monitor on him. I'll waive the fee. Okay. I guess, correct. No alcohol, no drugs, random testing, no weapons, no threatening or
You
harassing
can feel
contact
the
with the
tension
complaining
here,
witness.
a man pleading
the
to keep
scram
his job,
monitor,
a
waive the
judge
fees.
wrestling with risk and
Get
compassion.
with me as
This
far
isn't
as
just courtroom
the facility
drama,
and what they
it's real
say
life colliding
about
with legal
him
boundaries.
having the
How
device
much
on, and
mercy
if
should
they're
a
okay
judge
with it,
show
if
when
they're not
children
okay
and
with it.
violence are
If
in the
they're
same
not, then we
sentence?
can work something out.
Every word
But
here
the
could
minute
change
he
someone's
gets out,
freedom or their
the next day
future.
he's going to harass contact with the complaining witness, the scram monitor, waive the fees. Get with me as far as the facility and what they say about him having the device on, and if they're okay with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just
We'll get a reset, maybe 45 days out, should give us enough time.
do that. I need proof though. Like, get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. Feel free to get with Victoria so that way you can match up the date after you get the new date, and then
I have the paperwork. How do you want me to get that to the court on the?
if you want to email it to us, it's okay. Email,
Okay,
probably the easiest. That way you don't have to come in and waste time.
no problem. Yeah, I will get it to you right now.
And then just one more thing, always just CC Sebastian. That way they always have it as well.
No problem.
Okay, all right, guys. Mr. Castillo, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, an officer was working an extra job at Home Depot and was alerted by the loss prevention officer that the defendant had entered the store, putting multiple power tools in a basket, and exited the store with unpaid merchandise inside the basket. The officer was sitting in a motor vehicle and observed the defendant exit the store beyond all points of sale and head north in the parking lot. The defendant entered apartments across the street. The officer observed the defendant pushing baskets and approached the defendant. The defendant attempted to flee. The officer deployed a taser and placed the defendant in custody. The total value of items stolen was $519.98.
Got it. All right, Mr. Castillo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go back to any Home Depot. Do you understand? If I find that you do, I'm going to revoke your bond, put you in jail. No more PR bonds for you. You mind filing that, please? Okay. Tell me, do you have the ability to hire a lawyer, sir?
Yes, sir.
You don't want to apply for a court appointed? I don't want to talk about the case. Do you want a court appointed lawyer?
I mean, I could get one, but if I hire a lawyer, then I don't need the lawyer you're gonna give me.
Sorry?
I'm gonna go ahead and get a lawyer for myself.
Hey, you don't want a court appointed lawyer?
No, sir.
Okay. If you have a problem and you're not able to, just come back, let us know, and then we can appoint your lawyer. I'm going to have you sign a receipt of Victoria. I'll have you take a seat in the jury box. Let me get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Thank you, sir.
Don't pick up any new cases. Behave yourself.
Yes, sir.
Do you understand?
Yes, sir.
Okay, man, come on. Ms. Gray, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you now. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk and turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Gray, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an interlock for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand?
Okay.
Now, you have a great lawyer listed in Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand?
I do.
Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand?
I do.
All right. So I'm going to have you sign a receipt, Victoria. We'll have you get Fleischer for your bond conditions, and then you guys are free to go. All right. Thanks, guys. Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle and the officer was performing a felony stop.
Boom, case dismissed. Just like that, a man walks free while everyone else blinks in disbelief. But was it luck, a missing witness, or a flaw in the system? Moments like this remind us that justice isn't always about guilt, it's about what can be proved. Count this one as a rare courtroom twist ending.
On the possible stolen vehicle with multiple items in her hand, and the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of. The defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the patrol vehicle, to which the defendant refused and had to be escorted by force. The defendant kept moving her hands away from the officer and he attempted to handcuff her again. The officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
She the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop. Ma'am, don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm going to find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. Do you understand? Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it and then we can appoint you someone later today. Do not leave until you sign our bond conditions though, ma'am.
Yes,
All
sir.
right? Okay, please.
That's it, Judge.
Got it. You are Adam Reyes. Mr. Reyes, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On January 23rd, 2025, law enforcement officer observed a black Silverado and a white Honda Accord at the 7800 block of State Highway 6 turning left at a high rate of speed. The law enforcement officer made a U-turn at the intersection and followed both motor vehicles, having to travel approximately 66 miles an hour in 40-mile-an-hour zone. The officer observed motor vehicles to be side by side with the Honda flashing emergency lights. The law enforcement officer observed Honda turn off the lights. Both motor vehicles began to speed up again while driving side by side, and they ran a red light. The officer attempted to catch up with both motor vehicles, causing the officer to travel approximately 90 miles an hour in 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. Traffic stop was initiated. The officer made contact with defendant, driver, the sole occupant. The defendant stated when asked about high rate of speed, "No, I was on my way home with my friend Adam, and Adam was following me home." Co-defendant arrived claiming he was there to check on the welfare of defendant. The co-defendant stated, "I was following them home, but I broke off because I wanted to get something to eat." Defendant ID'd with a Texas driver's license.
And Mr. Reyes, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in this type of activity again. If I find that you do, I'm going to put you in jail and then I'm going to take your ability to drive away. Do you understand? Can you look to see if he has a valid Texas driver license, please?
Yes, Judge, eligible.
Okay. Do you have the ability to hire a lawyer, Mr. Reyes, or did you want to apply for an appointed lawyer?
I'll hire one.
Okay. I'm going to have you sign a receipt, Victoria. I'll have you take a seat in the jury box while we get your bond conditions, while we sign it, and after that, you'll be free to go. Be safe in my city. Do you understand? All right.
This way.
Mr. Thornton, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, the complaining witness and the defendant are in a dating relationship. And on December 18th, 2024, in Harris County, Texas, officers were dispatched to an assault call at a hospital. The officer arrived and made contact with the complaining witness, who stated that she and the defendant are in a dating relationship. The complaining witness stated that earlier in the day, she and the defendant were in an argument due to the complaining witness telling the defendant that he needed to leave the location. When the complaining witness got up to leave, the defendant pushed her through a wall, causing her to crash through the wall, causing pain. Officer observed the complaining witness to have a laceration over her right eyelid, swelling and bruising.
What's the problem with this case? You know, it shows it's dismissed. Something went wrong. Something's wrong. I'm showing that the case is dismissed when it shouldn't be.
This is Thornton, Judge.
Yeah.
Last question yesterday.
Or is it? I don't know. I don't even,
This one was signed.
It is a DVD case, Judge.
Or Mr. Witness.
I don't even see a nollie.
It's for Thornton. It's not published, Judge.
Judge.
I mean, ready to publish.
Judge, you said he spoke with Chief Campbell, dismissed for missing witness due to.
So it is dismissed then, right? Okay, your case has been dismissed, believe it or not. Just be careful out there, you know? Just, today's your lucky day. Count it, all right? Okay, man, good luck. That's okay, I did too. I don't even see a copy of the dismissal here. That's why I was kind of threw me for a loop, but Dave knows, you know?